This is.
I represent Mr. Clark. This is one of his.
This is Timothy Douglas Clark.
Correct, Judge. I'm set for a hearing. It's not necessarily a hearing. It's more just a request. Just a bit of a backstory is Mr. Clark was arrested and made bond sometime in 2024. There was an incident in Davidson County where he was arrested for domestic assault, which was subsequently dismissed. But even though it was dismissed, Judge Lockhart Mash revoked his bond, so now he's been sitting without bond. He is severely intellectually disabled, and has had many meetings with my own mental evaluator, who I believe has had some difficulty with him being in jail and getting some tests and stuff done. He's now completed his report. There is a facility with which he was staying at where he has a 24-hour guardian with him at all time. It's not necessarily a lockdown facility, but there are people that monitor him and his behavior. I know that there have been lots of issues in the jail, and their issues being that I don't think that they're probably capable of accommodating Mr. Clark the way he ought to be. So we would just ask for a bond. His family's indicated that they will make another bond if we can just get one at all. So we would just ask the court if we can have.
So if I'm understanding, there has been a revocation of this bond by a different judge, Judge Lockhart Mash.
That's correct.
And you're now asking for me to reinstate a bond despite the fact that a different judge has revoked it.
Well, yes, or just give us a bond. We don't have to
reinstate. Or to set a bond.
Yeah, set a bond.
And that bond you're asking for to be set is despite the fact that we're awaiting the results of a competency evaluation.
We should have that in the next couple of weeks.
Let me hear from the state.
My position is going to be the same it's always been. The facility that Mr. Vaughn is speaking of is where he was at when he got arrested. So they don't seem to watch him 24 hours a day. I think they're testified that they don't watch him 24 hours a day, but they do try to facilitate daily activities with him. But it is not a place that the state feels safe enough based on the charges he's facing to ensure that he's not going to get arrested again or come to court.
Well, first and foremost, because the original revocation of the bond occurred in front of Judge Lockhart Mash, the more appropriate person to hear this motion to reinstate bond would be that judge. Wow. Because this court does not typically go behind another judge's order to change the results of that judge's order. And you're asking me, I understand you're asking your client has filed a pro se motion for a bond. The second thing is that we're waiting for the evaluation results. And in my opinion, it would be ill-advised to reinstate a bond until I see what the results of that evaluation are. So,
okay, so we can revisit this once the report is done.
My opinion was we defer the bond request until I hear and see what the evaluation results are.
Fair enough. And for the record, Judge, it is on your docket. It's not just.
That's fine. Right. I don't have a problem with it, and I'll be glad to hear it, but I'm not going to hear it till I see what the results of the evaluation. When we send someone for an evaluation of their competency, that determines whether they're competent to stand trial. If they were found to be incompetent to stand trial, there is a provision under the law for someone to be institutionalized at Middle Tennessee to see whether or not they can be trained to become competent. And I've actually had a case in another county where the training resulted in that defendant being rendered competent to stand trial. So I'm of the opinion that at this point, it's premature to reinstate a bond until I see what the results of that competency evaluation are.
Understood, Judge.
So your client's motion to reinstate bond is respectfully deferred until I see those results.
Okay. I'll get with you.
All right. We're now ready on State versus Billy Lynn Hollis Jr. State of Tennessee versus Billy Lynn Hollis Jr.
Yes, Your Honor.
Right. We have two motions that are before the court. The first motion is for a motion to enforce an original plea offer. Second is a motion for a furlough into treatment.
Mr. Lockhart, I think they're your motion.
Mr. Lockhart, they are your motion.
We call him Mr. Billy Hollis.
Mr. Hollis, if you'll come up. May I ask you to raise your right hand and be placed under oath? Stand up if you will, raise your right hand, be placed under oath.
If you would state your full name for the court.
Billy Lynn Hollis Jr.
Mr. Hollis, are you in jail here in Cheatham County?
Yes, sir.
And how long have you been in jail?
About 2.5 years.
All right.
Be sure to talk directly to the mic.
And ballpark, when were you arraigned on these charges?
November 13th, 2023.
And did Mr. Scott Saul previously represent you in this matter?
Yes, sir.
And at some point in time, did he come to you with a settlement offer?
Yes, sir.
And did you appear in front of Judge Lockhart Mash on what would have been a date to enter a plea?
Yes, sir.
And what was that date?
January 14th, and then it got pushed off 2 weeks to January 28th. And that was the day I was supposed to sign it.
All right, on January the 28th, what was the offer you had at that time?
6 years community correction.
And did it require that you do anything as a condition of community correction?
Treatment, year-long treatment program.
All right. And on January the 28th, were you prepared and ready to take that settlement offer on that date?
Yes, sir.
What were you able to enter that plea on that date?
No, it was not.
What happened?
They never come and got me for court.
And did you find out why?
Not until 2 weeks later when Mr. Saul showed up with a completely different deal.
Did you find out that Mr. Saul couldn't be there on the 28th?
No, not until he showed up 2 weeks later. I didn't know.
Did you find out then why he couldn't be there?
Yeah, he told me that he had a family emergency.
Or had a family emergency or perhaps even a death in the family?
Yep.
Right.
Yes, sir.
But on the 28th, you were ready to take the offer.
Yes, sir.
And did something happen after that court date was put off in regard to your offer?
When he showed up, the 28th, it got pushed off. I wrote the court clerk and they said it got pushed off till June 3rd. And then on February 14th, Mr. Saul showed up and said that Mr. Arnold had left, that Mr. Stevens had gotten my case and was offering me a 25-year prison sentence.
So it went from 6 years community corrections to 25 years to serve.
Yes, sir.
And did Mr. Saul say anything to you about why the offer had jumped like that?
Just other than Mr. Arnold had left, Mr. Stevens got my case, said that he previously knew me, and since he had me here, he's gonna hang me. He's gonna nail me, and those was his exact words.
All right. Had you had dealings with Mr. Stevens before?
Yes, sir. We'd crossed paths in Clarksville before.
And based on the jump in the offer, what did that make you think in regard to Mr. Stevens taking over?
I mean, like a personal bias, possibly even conflict of interest. I mean, everything that, just the deal itself, from 6 years community corrections to 25 years at 100% to serve. Mr. Saul stated that, he knew me from Clarksville, and like I said, that he was gonna nail me. Since he had me here, he was gonna nail me. Those was his exact words. He told me before that, he's like, look, this DA hates you. You know what I mean? And I think hate's a personal thing. If you hate something, that's pretty personal. I feel like it's being targeted for something that I'm just not getting a fair shake here, I don't think. The deal was taken away from me unfairly. I was gonna sign it that day. And Mr. Saul had a death in the family, or for whatever reason, he wasn't able to show up here. So why wasn't I able to sign the deal the next time? I mean, I would have signed it that day.
After the 14th, or between the 14th and the 28th, had you satisfied your mind in regard to your Montgomery County charges.
Yes, sir.
And
Yeah, they was waiting.
regardless of what was gonna happen in Montgomery County, you wanted to take the offer Mr. Arnold made.
Yes, sir.
And you would have done that on the 28th
Right.
if you'd been allowed to come to court.
Right. I would have done it before. I never rejected the deal. Mr. Saul told me that the deal wasn't going nowhere. He advised me as my attorney to go to Clarksville, get them settled first, and then come back here. Once I got that done, that was in December. I got them settled. They was on board. I come back here in January, and then this one happened January 14th. They needed to know how long exactly, so they pushed it off to the 28th, and I would have signed it that day.
That was to provide time to coordinate everything.
Yeah, yes, sir.
But on the 28th, you were ready to plead and take the offer.
Yes, sir.
You also have a motion filed asking for a furlough. Have you ever been to treatment before?
No, sir.
And do you deal with drug and alcohol addiction issues?
Yes, sir.
And do you also deal with some mental health issues?
Yes, sir.
And what about your past help cause some of those issues that you have?
Childhood trauma. I mean, I was
Were you sexually abused as a child
yes, sir. When I was 7 and 8 years old.
when you were 7 and 8 years old?
Yes, sir.
And do you think if you had a lengthy inpatient treatment that would deal with your mental health issues and your addiction issues, that you could succeed?
Yes, sir.
And are you willing to do a 1-year-long program, whatever the court would
Yes,
see
sir.
fit?
Yes, sir.
Would you be willing to wear a GPS monitor if that was a condition of you going to treatment?
Yes, sir.
You've got a lengthy record, but you've never been able to address the mental health and the addiction issues. Is that correct?
Right.
Do you think if you could address that, it would make a difference
Yes,
in
sir.
how you behave?
Yes, sir.
Anything else you want to add to the court as to why you think you'd be a good candidate for treatment?
I just really had a lot of time to sit in here and think and reflect, and I really want a chance at, changing my life and getting the help that I want and need. I never had that opportunity.
And if the court were to allow you to take the original offer, would you complete your loan program as a condition of your community corrections if you're allowed to do that?
Yes, sir.
Anything else you want to tell the court as to why you feel like you could succeed if given these opportunities?
Well, and just really want a chance, please. I ain't never had the opportunity to go to rehab, and I've always just been kicked right back out into the same environment and never actually had any help.
All right. No further questions.
Stevens, you may cross-examine.
So, Mr. Hollis, you're here today asking the court to enforce your alleged prior agreement, and if the court doesn't do that, to furlough you, correct?
Yes, sir, or do both.
Okay. Let's go over your history for impeachment purposes on both of these motions and your likelihood to appear regarding the motion for a furlough. In 2019, you pled to a diversion for 4 auto burglaries, correct?
I believe so.
Okay, so you were given the chance to have this come off your record if you were successful, correct?
Sure.
Did you do treatment during that time?
Need treated.
When you were given a chance to do probation and not be incarcerated, in fact, get a diversion, did you do treatment at that time?
And I guess I went to a 28-day program, and
Okay.
they told me that that wasn't rehab.
Okay, so
They
then
stated that.
in 2020, while you were on this diversion, you were charged with and ultimately convicted of selling meth, correct?
No, sir.
You are convicted of a felony meth charge, possession with intent?
Sir.
Okay.
Not
So if the records show that, that would be incorrect?
for for selling meth. I've never charged for selling meth. I might have got a possession charge for meth, but it was never meth in scales or anything like that to indicate that I was a dealer.
Okay, so if you pled to a felony meth charge, that would be incorrect.
Yes, I have a felony meth charge, I guess. It went to circuit court, but it was a half a gram. Anything over a half a gram is considered felony.
Okay, you were given probation for that. And did you seek treatment then?
Sure.
So that was another chance of not being in prison, and you did not seek any of this treatment at that time, correct?
I was supposed to go to treatment when I was homeless. I got kicked right back on the street. Within 3 days, I was expected to go to probation with no license, no car, right back in the same environment. I've never actually been, anybody helped get me there to the place.
That's interesting you say that. In 2021, you got in a car with Agent Matt Farrell, and when he lit you up, you took off from him at a high rate of speed, didn't you?
No, did not.
Okay. You were incarcerated a little while, and then you were released in 2022, put on probation again, correct?
It was the first time that I actually come across you in incarceration. And I begged for treatment then, for you to send me to rehab then, and you would not do it.
Do you recall May 2022 high-speed chase you were in where an injured or an innocent person T-boned your car at the intersection of, I believe it was River Road and Dean over by Food Line in Clarksville? Do you remember that?
Who was driving?
Megan Byrne?
And I was a pastor.
Yes.
Okay.
Do you remember that?
Yeah, I remember that. It was Vanderbilt. Had 3 broken ribs and a lacerated kidney.
During a high-speed chase with law enforcement, I believe it was Deputy Thompson, correct?
Deputy.
Okay.
But I was also just a passenger.
Drugs were found in the car,
And
correct?
as we'll go backwards to that thing that you just said about Matt Farrell. She was my co-defendant in that case, and she even wrote a statement saying that she was the one driving in that case.
Okay. So a warrant was filed for your probation. A warrant was filed for your probation violation in February 2023, correct?
So
Did you turn yourself in?
I didn't know about the warrant. At that point, I was back on drugs
Were you going to probation as you were supposed to?
up until I started getting high again. Yes, sir.
I'm not going to go into the charges today specifically. I don't want to talk about the facts of them. But you were found and charged with the new offenses while you were on probation. That was August of 2023 for these charges, correct?
So I got an amended warrant for that.
Yeah.
I would like to just state though, up until I relapsed, I was still going to my probation officer, even after I got into that car accident.
So if they had had a warrant in February of 2023, they would have had the chance for 6 months to serve it on you. That's your testimony?
When was that car accident?
Okay. Let me move on. So you have a history including 5 felony convictions, correct?
That's what I'm on probation for.
Or maybe actually 6. Let's see. Including taking off from law enforcement. You pled guilty, but including taking off from law enforcement, Agent Farrell in that case, correct?
That was the day that me and you went back and forth. That was the first time that I ever come across you, actually. I never heard of you.
When you say go back and forth, you mean through attorney, correct? I never spoke to you.
Right.
Okay.
Which my attorney though that day advised me, he said, do you know who Mr. Stevens is? And I said, no. And he said, well, he's taking a personal interest in your case.
Who was this attorney who said that?
Alexis Spada.
Okay. Let me go through this. So you have felony evading by motor vehicle charges in Montgomery County pending, correct?
There is one pending, yes.
Driving recklessly. Pending, correct?
So,
Multiple counts of burglary pending, correct?
one count pending.
And
It is-
theft over 10,000
It's
pending.
gonna be reduced.
It's going to be reduced, but you have charges right now of all of those counts. Theft over 10,000, burglary, driving recklessly, and felony evading. Those are new charges still pending, correct?
They're pending, but it's already settled. I'm gonna get either furlough to treatment and community corrections or whatever. That's what I'm currently waiting for here.
Okay, and you also are on 9 years of probation out of Clarksville as well, correct? And none of that's been resolved with the courts at this time. Nothing's been entered in. You pled to nothing in those courts, correct?
Correct. We're waiting here. They keep pushing it off so I can settle this here, then go there and sign my community correction.
Since August 14th, 2023, you have had no new charges since that day, correct? That's because you've been in jail, correct?
Correct.
That's all that I have. Thank you.
Redirect. Thank you, sir. You may step down. You may call your next witness.